lights that used to be there.
You no longer can see the bomb up there in the light picture.
Some of the mayors were, previous mayors were a little upset that we got rid of what was discussion. That was a discussion.
You're gonna start recording.
Excellent. Well, thank you all for being here for this tonight's special meeting of the City Council on October 30th, 2023. We'll first get started with a roll call.
Christopher Lepore,
Here.
Diana Crawford,
Yeah.
Ruth Causey,
Here.
Chaz Jones,
Here.
Teresa Nielsen,
Here.
Matt Lehman.
Here.
And staff, we've got Chelsea Starner and City Manager Chris Workman.
And Jessica Andrade on Zoom.
Sorry,
Present.
online, we've got Jessica Andrade.
Present.
Thank you, Jessica. Excellent. So tonight we are here to have a special meeting to interview city attorney candidates because our city attorney is retiring on April 1st of 2024. We're first going to get started with a discussion of the city council about the process and the interview and then the review questions. And then at 6:20, we'll have Cable Houston will come and join us, which is one of the law firms. At 7:15, we'll have the second law firm, Beery, Elsner, and Hammond, come and join us. And then at 8:15, we will have Ivers, Miller, and Mazhari Clark law firm be joining us. So so anyway, we first have the matrix, so we can, each of us could have two questions, two that are the same with 6 questions, and those are for the 2 candidates for city attorney services that do not include litigation. And then prosecution, and then the version has 5 questions for the prosecution. Maybe.
I have the 5-question one.
You don't.
I just have the 6th question.
Okay. Perfect. So we will first get, so the 5-question one is the third. And it, or that'll be it. So starting with review process, the plan is that we'll each be taking 1 question and we'll just go around. If assuming that Jessica will be able to ask one question when it comes to her, we'll go ahead and have her ask one of those questions unless she asks us to do otherwise.
At this point, it's probably better if you do. Yeah.
Not a problem. Happy to do it. So we ask each of the candidates will have 40 minutes to answer their questions. And we have the 6 questions and the 5 questions. It's really important that we treat all of them equally and that we allow them the full 40 minutes to answer all the questions. So we don't want to do something different for one candidate versus the other. So the plan is that we'll just go around the room and ask 1 question at a time and allow them to manage their time appropriately. But first, they're going to do a short presentation, 4 minutes. Is that the plan? Short presentation on a topic that were given to them previously. Then we'll ask, we'll go through these questions in 40 minutes. And then we'll have a 5-minute break before the next firm comes in. Chelsea, I know I missed one thing that you told me that I should mention.
I think you covered it, just so you know, only write on these sheets for each of the firms. You will be sending these in at the end if you need this for some reason. I can get a copy scanned to you, but I need to think these at the end. And yeah, I think you just said stick to the questions, just like you're basically in a job interview. It's a little bit different, but stick to the questions. and then the matrix, yeah, at the end. So I included, this is the matrix that's specific to this part of the hiring process that was in the RFP. You do not need to do this tonight. I just wanted everyone to have it, so you saw what the format is. And then additionally, one of the counselors, firm specific questions that really just were about the firm. Are they willing to discount travel expenses if they travel here? And are any of the references specific to the attorneys that they would have working with us? So they were firm specific. Jim Brewer did say that we could ask those via email ahead of time because they were not questions for the other firms. So that's the other two things we need to touch.
Yeah, so those questions are here. And the answers, the questions are on one side and the answers on the other. And then, before I get to Dan, regarding this, each individual counselor and mayor will then just score each candidate on each of those two topics. So however we wish to score them is up to us.
I'd recommend that you do that scoring tonight and submit that tonight as well, just because.
Yeah. Okay. And let's progress.
We were told not to, ask follow-up questions for one firm and not the other. So if you have anything that you're gonna ask the first firm, we need to ask each one of them. Isn't that right?
We're gonna try to.
Just stick with it.
I will make note of that. I mean, the part of the interview isn't to see which firm is going to interview the best. We want to know which firm is the best. So if you feel like they didn't quite answer the question or there's more there, ask the follow-up question. That's fine. That's more than appropriate to ask a follow-up question to try to get a more complete answer, because what we want is the answer, right? It doesn't just so you can say, oh boy, they completely blew that question. They didn't even answer it. Well, we want them to answer. We want the answer, right? So if you feel like they've missed the mark, or maybe they've given a response that maybe was a little bit different than what you were anticipating, feel free to ask the follow-up question. And then on the staff side, we'll just make sure that we give a similar opportunity to the other firm as well. So we'll treat them equally, but we'll just go that route. And if it's the second firm that you need the follow-up, again, use the follow-up. We don't want to be so restrictive that we're gonna miss an opportunity to learn more about the best potential firm. Just be conscious of that as you're asking those follow-up questions.
One thing I don't want to do is ask a follow-up question and make it so that firm can't answer all the questions. So that's what I really want to be cognizant of. So I'm hoping that we can go through the questions at least once and then ask a follow-up question, so that if we have to write down your follow-up question.
Were they told that there were 6 questions, so they,
Not yet.
No, we'll tell them.
okay, so they adjust their time and their answers to not have a 20-minute answer to one question. And
Yep, I'll give them that guidance.
Unless it's the only question that we want, the
Okay.
whole 20 minutes.
Know that you don't know that. So I don't want to ask that question. I know, but I don't know what a home rules.
Okay.
Question.
Come on in.
Come on in. Okay.
That's okay. You
Come on,
got
Andy.
a seat. Ready for you just a minute.
Are there any other questions? Process?
Question?
I'll just start on one side and let them go us around the room. We're all equally qualified.
Congrats.
Maybe I'll start over here, just mix it up.
I couldn't take.
Yeah. Anything else? Any questions? Well, it's going. Good. Right. We should wait until 6:20, or can we start and then just? Well, I'm Mayor Chaz Jones, and I really appreciate you coming down and talking with us and taking the opportunity to interview, see what we think about the different options for our city attorney services moving forward after our retirement of our current firm. But, just so you have an understanding of the process, well, first, we offered a question and we had each of you give a question and then you'll give a 4-minute presentation approximately, right? And you know that question already, or you've been given it?
On public meeting
Yes.
updates, okay, sure.
And then, after that brief presentation, we have a series of, and I'll remind you of this later, but 6 questions that we'll have 40 minutes to cover. So you're just gonna manage your time appropriately. And then after that, you can go ahead and exit and then we'll bring in the next firm. So, any questions? Okay, and what was your name?
My name is Laura Westmeyer. I'm with Livingston.
Yes, we'll start. We do have about 10 minutes for introduction,
Okay,
introduction to your firm, and then you can go into the topic that we gave you whenever you think that's appropriate, but would love to know more about
Yeah.
you and where you're coming from and see if we can tell us about that.
okay. Yeah. Thanks for having me here today. I know I did see your agenda and it's quite a lineup, so you have a marathon interview. I come from Cape Houston, so again, my name is Laura Westmeyer. And in our proposal, I am proposed as the principal attorney to be working with you. I don't know how you worked with, was it Jim Brewer in the past? I'm not sure who communicated with directly. Typically for us, it's either the city manager and or the chair or the mayor of a city or governing body. You know, you set it up. So then the city manager would be connecting us to department heads to work directly on different matters. And of course, we are tactful to you, everybody. So
I'm sorry, can you speak up a little, please? I'm on
Oh.
Zoom. Thank you.
We do have one counselor and she's in a car driving down.
Or Andrade, and just so you know, this is our sound system, so
okay,
you are a little bit further away from it, sorry. One of the firms was going to bring a number of people, so we just scooped you out a little bit. We
okay.
can always also move you up if you want to rather sit here, maybe you can speak. Would you rather sit here? I can switch you spots.
I'm happy here, Counselor Andrade. Are you able to hear me better?
I can hear you better now that you're speaking a little louder,
Okay.
or it seemingly feels that way.
No, what? Okay, thank you for that. I will try and speak slower and clearer and a little bit louder. So even though I am here on my own, I hope you can see from our proposal and from my responses to your questions tonight that you really have a full ton of attorneys available to you. We have 26 attorneys at Cape Houston. We are based in Portland and we're a general practice firm. So we have attorneys that are experienced in really a variety of areas. I think I'm certainly touching public entities. And the ones that we selected to put in our proposal are really what I would call our public sector people. We are all very much mission-driven people at the firm, and we really take pride and feel very strongly and passionately about representing public entities. So those are kind of your go-to folks. So some of those people, I guess I'll back up and say I am more of a generalist. I worked with and for governments for about 15 years. That's really my primary passion and purpose. Probably the only reason I'm at a private firm is to serve public entities. And at Cable Houston, we have a variety of them. We do mostly special districts. We have special counsel and general counsel, and also counties. But basically, you name a public entity, and we serve that type of entity. So we really have a breadth of knowledge in all public entities. And I feel particularly excited about cities because you, as a city, as you know, you're very, very accountable to people and very visible to the people, and probably the first sort of government that your community thinks of when they think about a government, because you're affecting their daily lives. So I'm really excited to work with cities in particular, and that's why I'm sort of personally here today. Did you want to know anything else about the firm? The people?
Quite good. probably go on to move on to the short presentation that you have, and I will just reiterate the question. You're going to talk about public meeting law changes coming up in the next year and the impact it will have on Philomath.
Mhm. Well, I suppose I should say,
I'm sorry, we're supposed to ask the other question first specifically, or that part of the intro?
No, I can just ask that. I just wanted to confirm, the proposal, because we had it either both or separate. I just wanted to confirm that you are interested in doing just the city attorney negotiating contract for that without prosecution services, that you would be okay with that if that's what we chose.
yes.
Okay, because we did receive a proposal just for prosecution services, so we're just
Okay,
weighing the options on that.
that is correct.
Okay.
And really, I actually personally do have a good amount of experience in city prosecution. It's just a capacity issue.
Right.
So we really can't do both this capacity wise. So
Okay.
it is only for city attorney services.
Thank you for that clarifying question. Yeah, so a short presentation topic on public meeting law changes coming up in the next year and the impact that will have on Philomath.
Thank you for the question. You're going to hear probably updates in law several times tonight. I don't have a formal presentation, but you know, as part of what we do is certainly keep abreast of changes in law that are affecting you, public meetings being one really obvious one, public records and all of the like. So from the past legislative session, we did have probably a dozen updates to public meetings laws, not all of which apply to this city or to cities at all. Of the ones that are applicable and are changes that you should be aware of, I was thinking about them on the way over and believe there are three I would speak to you about. The first is sort of I guess I'll speak to them in terms of least impactful to most impactful. So the first is the legislature has provided new allowances for the ways of going into executive session. So public meetings laws require that the governing body of a public entity hold open meetings, meetings that are open to the public, which you're doing now, of course, unless certain narrow exceptions apply, in which case you can go into a closed or executive session. And I'm sure you're all aware of this already and working with it twice a month at least. But those exceptions are really narrow and they are frequently tested, I would say. So there's pretty much 12 that are more commonly used by cities. And now we have 14 available. So the legislature added two. The two that they've added are if you would like to discuss information on cybersecurity threats or potential cybersecurity threats to your system. And the second one is if you would like to discuss or talk about matters relating to the safety of public officials, of your staff, or of public facilities and buildings. So sort of safety related, and for obvious public policy reasons, you need to have those conversations, or you could now have those conversations in private, so that people aren't able to listen to how you're going to deal with public facility threats. So those are two additional opportunities to have closed sessions. Second change I would mention is very relevant to each of you as a public official. So one of the larger overarching changes is the Oregon Government Ethics Commission, which maybe you're already familiar with because they sort of administer Chapter 244, which is the government ethics, which apply to all of you in this room. They are now in charge of the administration of public meetings laws. So one of the duties that they have been assigned through the last legislative session is to come up with a public meetings law training, or to delegate the coming up with that training. And the new obligation on governing officials is to go through a training once each new term that you serve as a city council person. So that change goes into effect January 1st. The training has not yet been developed. So, we'll wait and see on that, but this isn't the kind of thing where your next city attorney, you know, if it's us or someone else, so we do, of course, do trainings for city councils on a variety of topics, any topic that you want to have more about, you know, is coming to a training, but that's not going to satisfy this requirement. It has to be this sort of sanctioned training that is forthcoming from the Oregon Government Ethics Commission. You need to provide verification of that also, that you did attend during your each term that you're in office. So that's a new, really relevant one to each of you as a member of the city council. And the third, and I think the most potentially impactful change or update in public meetings law is to create an entirely new grievance process and a new grievance scheme. Previously, if any member of the public had suspicion that there had been violations of executive session laws or public meetings laws, they would need to go to circuit court to challenge that. And I wouldn't say that they, at least in my practice in the last 11 years in law with public entities, I haven't seen that as being terribly common. Now, in the last legislative session, and again starting January 1st, the governing body, any member of the public can file a complaint for an allegation that the governing body or a member of the governing body has violated any public meetings law or executive session law, and they produce that challenge to the governing body itself, which now has 21 days to respond to the grievance. And the response has to be specifically to admit or deny with facts whether that allegation is true or false, and if you admit it as a governing body, then explain how you're going to cure or rectify that violation. If you're denying it, then you produce facts saying why these are the facts, but this is not a violation for XYZ reasons. You also need to file a copy of that response to the Government Ethics Commission. And I think this is important. It is important, and it is a big change because this is a much closer, a much more local grievance process. So it's used much more frequently, since all it really takes is a written statement to submit to the governing body. So in terms of effects for the city, you would want to, of course, come up with the process that you're going to use for who responds, so that if and when you get your first grievance, you have that already in place. If you're not needing to call a special meeting to figure out how to handle it.
Thank you. Got a little bit over just starting, but so now we have 6 questions, and should we go 40 minutes from now, or should we take off 4 minutes?
Yeah, we just want to make sure that we try to stay on time so that.
So we have 6 questions, and the first one we start with Council Lehman.
So what is your experience handling construction contract disputes and litigation?
Oh, well, we have, so again, I come here just on my own, but as a firm, we certainly are pretty much always in the process of handling construction disputes and litigation. The one that I can think of as a firm that we've recently been handling is for EWEB. We represent EWEB in litigation related to wildfires that took out a bunch of electrical power to folks. So we're involved in that one, as well as again for EWEB, there was a construction defect case concerning a bridge that I really don't have the details at this time, but I can provide them later if you'd like to know the details on that. But in that, we did on behalf of that entity go after the contractor and have damages and put them on those claims. in terms of construction contracts, you know, apart from the litigation, which really isn't my area of expertise. And I would turn you over to our litigators, our public entity litigators for that. But construction contracts, hopefully I'm working with you to prevent, these, challenges because we have a solid contract to work with. So I'm really familiar with the AIA contracts. You know, either it coming from engineers or architects, I work with all of the culprits, and have worked on public procurements, looking at, through the alternatives NRGC process, to just regular public improvement contracts.
Thank you. Comments?
Would you please provide an example of wherever you have provided balanced legal advice where differing sides of an opinion are at play?
Legal advice, where
Is
different legal opinions.
Is this pertaining to council more specifically?
Yes, is it pertaining more to council?
So more to council, if you have council that has different opinions. In their chamber.
Well, I would say, so, you know, and I'd love to hear from you after, if I have an opportunity for any questions, to hear how you prefer your city attorney to give advice to you and to communicate. But my sort of default would be, I don't typically, unless there's a clear legal, this is right, this is wrong, this will be very high risk, this is low risk. I wouldn't necessarily be providing you with a specific recommendation unless you directly ask me for that. I would be providing you with options and the risks and the pros and cons for each of your decisions so that you as the policymakers are making the decision. So I guess that's the first sort of offhand comment I would say to that. Generally, I guess specifically the first scenario that came to mind or matter that came to mind is currently I am the appointed city attorney for the city of Mosier in the Gorge, and the city is currently looking at short-term rental regulations and adopting those for the first time. This is, you know, as you're probably aware, in communities pretty divisive as a topic, and it can have, people have many different views. There are many different stakeholders in each community who have different ideas on the topic. So from that, I have been involved with the stakeholder group that they convened as a city council convened a stakeholder group of all different voices to come up with a recommendation to bring to the governing body, which is where they are at in the process right now. And so my role in that was to help the committee come up with balanced, but all legal ideas. Make that recommendation. Does that answer your question? Yeah. Okay.
To be clear, it's not the person that's reading the question actually developed the question. Excellent. How would you describe your negotiation style and methodology?
Negotiation style. Say, you know, of course, coming into this interview, I was looking at the city in particular, your budget, your mission, your strategic plan, and all of that. And the mission really jumped out to me to be responsive and ethical. And I think that's probably how I would start. Is that really speaks to me to be responsive and ethical is part of my my own mission. I believe in negotiations, I would say I'm pretty transparent. I'm transparent and reasonable. And so in advising anybody, my client in a negotiation, I would take all of the facts, certainly get all of the facts, and sort of understand the position of the other parties involved and interested parties involved, and then go to my client to talk about our leverage and advantages and disadvantages, and then probably recommend a reasonable approach, and then go back with that. Well, I would say I have a lot of success in negotiations, just being transparent and reasonable, and that would be my default.
Okay. Provide an example of a home rule challenge are aware of and how you might advise a municipal client.
An example of a home rule challenge that I have been a part of. I actually have.
Aware of.
Aware of maybe case
Okay.
law or anything. Just the subject.
Home rule challenge. No, I think I need a couple minutes to come back to that one. Nothing is immediate. I have not dealt with the home rule challenge. I worked for, yeah, in counties, I've always worked for statutory counties, not home rule counties. Obviously, cities are primarily home rule. But I can't say that I personally dealt with any, home rule challenges. Is there one that this city has been facing?
Not specifically.
Not recently, but yeah, it just talks about an example of home rule, doesn't have to be something you've dealt with personally, but. There was a home rule thing that was up for, well, you're the expert on.
Oh,
So there's been a recent example in the news of, let's see, in the metro area. That the city council are facing recall petitions, and they've refused to accept the petitions on certain grounds, and the Secretary of State is now stepping in and saying that they don't have the right to rescind those petitions as an example of the home rule conflict that you might encounter with the city against the state.
Mm.
The question was just, find an example of a home rule challenge you're aware of and how you might advise a municipal client.
Well, so, I guess, maybe if I speak generally, an example.
Great.
Narrow in. Home rule is so obviously home is an idea that cities are coming up with their own charter, and they have a charter that's elected by the people and written by the people. The state institution allows cities to form statutes, allows to provide for one form of incorporation. Cities with charters, like cities have decided to incorporate right for the people. So the question with home rule challenges is always if the city charter, I mean, typically it would be a charter question. If the city charter allows the city to do one thing that is potentially, that is touched in law in a statute, that's not like the ORS 221 statutory city statute, then is that law preempted by the state, or can cities have that plenary authority to move forward with that action? So I guess the examples of where it's been superseded and cities cannot act on appropriate cigarette tax and gas tax.
Sorry, can you speak a little louder? I can hear everyone else really well.
I will try.
Thank you.
And those are areas of law where the cities can't act under their home rule authority, which is otherwise pretty broadly understood as being plenary authority.
Okay, moving on to the next question. Describe your firm's experience working on a topic relevant to urban renewal agencies.
Well, so the cities that we work with urban renewal agencies, urban renewal agency is obviously a separate entity than the city. So they typically have different counsel. Not sure how you did that with your last city attorney. If it were represented both.
Yes.
Yeah.
Oh, okay. So we typically don't, we typically represent the city and, refer out to the urban renewal because the interests are not. So it is, even though your interests are mostly aligned, they can be adverse, especially, like in budget and finances in particular. So I don't personally have a lot of experience.
If you could just talk about why those two things are in conflict a little bit.
Why they're in, well, they have different. So in urban, where I have dealt with urban renewal agents is the urban renewal agency is now going after a private property for the assessments that they've that are due and how to actually enforce that. In that case, you have well, the urban renewal agency is the one passing, sorry, Mayor Jones, to answer your question, the first example that comes to mind is again a budgetary reason. So urban renewal agency has a different governing body. They have a different taxing authority than a city does. So they can maybe put out a bond that they will be obligated for that the city is not obligated for. So that is a conflict. If there's a problem with that bond and they can't be paid it back, that doesn't now become the city's issue unless you've kind of completed the governing bodies and now there's like a mixture of things. So that could be a really serious issue.
Good, thank you.
Thank you. Can you describe your firm's approach to balancing the needs of small municipal clients versus those of larger municipal or county governments?
I will say we really don't consider the size so much in when we deliver services. All clients are our public entity clients are equal priority. So we deal with matters in order of how pressing they are. Probably if there is a sort of only one person to get this done and we have all of these things to get done, it would be talking with the clients and both of them or all of them and having a conversation about what is actually the deadline that they're facing. Most of our clients do understand that, as much as we would love them to be our only client, that we do have others, and most clients have been really understanding of that, and I think that what we try and do is set reasonable timelines and expectations on deadlines. One of the things that I have found work really well for working with public entities in particular is to set up a weekly check-in meeting, so that the weekly check-in, we're kind of aware of things that are coming up so that we can know how to prioritize on our back end with what needs that the city will be having.
And I'd like to take the opportunity, we can do this for the next one too, but we have time left over. Is there any question you'd like to revisit? Or anything additional that you'd like them to say?
Oh,
Because that was the end of the 6 questions.
okay. Can I continue to ask some questions of you?
Sure.
Yeah, I'd love to know how you prefer communication and working with your attorney, maybe ideal characteristics that you have for your city attorney and what you're looking for.
Let's pick on that. Well, I think you probably learned that our attorney has been with the city for a long time. So This is new.
I think a very cordial relationship with the city attorney's office. They work primarily for City of Corvallis, City of Philomath for a number of years. And so, we didn't have formal weekly meetings, but definitely for my office, been in contact with the city attorney's office on a pretty regular basis. Maybe a week or two goes by at the most before we're checking in and following up on things. The city council has always had pretty free reign to contact the city attorney's office, even as individuals on the council, if they've had specific questions come up. And then that's usually come back to that council member and the city manager, and then I kind of disseminated the information back out. Counselor so-and-so had a question, posted to the city attorney, here's the response, and I'll forward that back out to everybody. I think going forward, recognizing how good we've had it, I think going forward, one of the first challenges that the council will have is to kind of formalize some policies on engaging with the city attorney's office and what that looks like and how that communication package will look. Because I think we've frankly been kind of spoiled in the past to have such great unlimited access to our city attorney. And it's something we should recognize. It's probably not going to be a luxury going forward where we'll be looking at getting billed for those hours and, just need to have a little more formal process set up so we don't feel like we're lacking. But we won't have quite as informal ongoing relationship. So
I think it'd be a challenge to just knowing that we've had such great access, like he's always been to he's always at our meetings and everything. And going to some other model might be just a challenge for us as a entity, not just this one, but in future councils as well.
I think I've kind of seen both sides of it because I agree that this council is like, we've had an excellent relationship with our city attorney and it's been very, casual and back and forth. And like, we all feel very comfortable just kind of asking questions and getting feedback. And then I also served on our school board where it was kind of the opposite, where like, we of course had a law firm representing the school district, but it was like, the school board was always like, that was like the last resort to like ever ask the attorney any questions. And there were some things I was like, no, I really feel like we should ask we have the law, like just send them this and ask them this. And I think that was maybe too far in that direction. So I think we'll have to find that balance where, yeah, we probably don't need to ask the attorney every single thought that pops into our head. But I think also understanding that like, there's a reason we have a city attorney and we should use them and we shouldn't just kind of figure out our best guess on things. So I think I would hope we can lean more on the side of using them, but I think that we will have to kind of figure out like, does it have to go through the mayor or the city manager, kind of how that works. So I guess that will be something that our incoming city attorney will get to help us sort of figure out a new culture around, but yeah.
Absolutely. I think to that, we do have public entities that we work with. We work very differently. And so some that don't have as many staff resources, they do tend to use us more heavily, almost like we are staff, and doing things that if you're looking for where is that line, I'm happy to, or we would be happy to tell you it's something we can do, but we don't necessarily need to do that. We can give you some guidance or some bullet points and look at maybe a draft or something, but it's something that your staff can do, or we're happy to just do it, just depending on your resources and what you're looking for. So of course, that's going to be more of a business financial question.
Did you have anything else?
I don't have anything else.
No,
From anything else?
can we do that or follow up?
I have one. Regarding to Zoom, what's your take on the negativity of Zoom as Zoom representation during a city council meeting? Is that typical for your firm to Zoom into meetings rather than attend in person, or what is typically the case in small cities?
Very typical to attend virtually. In fact, some of my jurisdictions since 2020 have never returned to in-person. So everybody appears on Zoom. Say, in terms of administration and how effective the meeting is. It's much better if either everyone's on virtual or everyone is live. So I think where cities, such as Philomath, obviously we're coming from Portland, so it's an hour and a half away. So we're happy to do, for jurisdictions who are more in this situation, we typically attend not every meeting, but perhaps only meetings where we don't attend live for every meeting, but only meetings where it's really helpful or important to attend live because it's maybe a workshop where a legal issue is kind of front and center, or an executive session where we really want to all be in the room talking candidly about something. But that's going to be at the discretion of the city. We're happy to come live whenever you would like us to come live. But it does work for many jurisdictions. We are on a hybrid approach. It's just a little bit more comfortable.
Any other follow-up? Well, thank you so much, Laura. Really appreciate you being here. Thank you for your time, for driving down.
Yes.
Half on a good day.
Yes. Good, good. Thank you so much. Why don't we go ahead and take a 10-minute break?
I just, at what point will we deliberate? Is that on the night? Okay. Perfect.
We'll go ahead and take
Try to
a
remember all these thoughts up here. Well, but some of them. I'd rather keep up
But I can
here.
You're gonna keep
I can scan you a copy.
Because I just feel like, some of these I wrote like 2 words and in my head, I'm like, oh, I know what that means. And now I feel like by the next meeting, I'm like, what do those 2 words mean?
And the clock ready to follow?
Well, I just had a question. What, if we were to email them, do they start the clock and check it for the emails? And it's a 5-minute process.
Every 6 minutes.
I know, isn't this fun?
Oh, I love that. Yeah.
It kind of makes me want to become a lawyer.
I would not do that.
For a minute, get paid for 6.
Yeah.
Just go take a 10-minute break. We'll come back.
Now look at your backs.
Yeah. Excellent. Really appreciate you being here. Well, first, this is Deary, Elsner, and Hammond. And we're gonna get started and we'll allow you 10 minutes to offer a little bit of a introduction to you and your firm, and then to answer the question, and then to answer a question about whether or not you're willing to negotiate a contract for city attorney services only, excluding prosecutor services, because we did get one applicant that was only in prosecutor services. And then we have offer a little short 4-minute presentation on public meeting law changes coming up in this next year and how it will impact. So let's go ahead and let you go ahead and start that introduction. If you have any questions, we can tell you again what that was.
Great. Well, thanks again for having us here. I'm going to start off. My name is Chad, and I'm one of the partners at Deary, Elsner, and Hammond. And with me, we have Emily, Josh, and Ashley. And we brought 4 of us tonight, which may seem a little overwhelming, but it's sort of how our firm operates. Our firm was started back in 1998 with the idea of being outside city attorney's office, similar to what the bigger cities have. Knowing that smaller cities in Oregon don't have the opportunity and can't afford to have that level of expertise, the founders of our firm said, well, why don't we do that as an outside firm and then offer those services to smaller cities? And so that's exactly what we've been doing for 20 some years now. I guess 25 years now. And it's worked out really, really well. And what we do basically is have a team approach. We have 1 or 2 lawyers who serve as the lead contact for a city. And that allows you to always have someone to contact. So, I'm not just calling the office and asking for random people, but you get to work with all the attorneys in our office. So what we like to do when we come to these types of interviews is bring several of us so you can sort of see how we operate. You can meet several members of our team and get a better idea of this is what your life will be like with Deary, Elsner, and Hammond as your city attorney. Our firm, again, we were founded with this very purpose in mind. And the only thing we do is represent local governments. We don't take on any private clients. And we do that for 2 reasons. One is it allows us to really become, I think, the true experts in municipal law. And it's an extremely complicated field of law. There's a lot that goes on for cities, and it's very difficult for people who don't do this full time to really understand the breadth of knowledge that's necessary for this type of practice. The other aspect of what we do and why we do this is because it keeps us free of conflicts from private clients. So a lot of times, larger firms that have done this kind of work or do this kind of work, they have private clients, and some of the lawyers in their firm are representing private clients before other cities and taking positions that are adverse to what the cities generally want. And so it's difficult for you to be on one side of an issue saying, for the city, we advocate this way, and for our private clients, we advocate the other way. And our firm has always found that to be this issue kind of conflict a pretty big deal. So that's why we don't represent private clients. We just like to avoid those kinds of conflicts completely. And so we, for the most part, represent cities. Went back and looked today, and I think I sent an email to Chelsea where I said nearly 20 cities. We're actually at 21 cities now where we're their full-time city attorney. We also represent various cities as special counsel doing projects, whether it's litigation or drafting a charter amendment or various kinds of special projects where their city attorney, for whatever reason, feels they need a level of expertise that they don't have, so we help them out. We also represent some counties and some special districts, but not many, for the same reason that can cause conflicts as well. So most of our practice is primarily focused on cities. And it really, I think, allows us to have a breadth and depth of knowledge that's unmatched in Oregon when it comes to cities. And so that's sort of the overall aspect of our firm. And unless you have any immediate questions for us, I'm going to turn it over to Ashley to do the presentation on public meetings that you asked for. But before I get there, to answer your specific question about city prosecutorial services, we can do that, but we actually recommend that you go with a separate entity. And looking at the application for the people who submit an application, I think it's a no-brainer to go with them. We do that for most of our clients. We work with a separate city prosecutor, and then if needed, more complex matters, some recent examples are like zombie houses. During the downturn in the economy, banks basically let houses in foreclosure just sit there, and they became eyesores and really complex issues dealing with the banks. And so we would often step in for the prosecutors in those situations, because it's just a more complex case. But otherwise, honestly, when you're talking about your typical, muni court prosecutions, you get better services at a much cheaper rate by using some of those people who specialize in municipal court prosecutions. And we work well with them. And I think, from our perspective, it's certainly a no-brainer to go with folks who've been doing it for you for a couple of years anyways.
Thank you.
Great. Well, hello, everyone. My name is Ashley Gill. I would be one of your main points of contact at Barry Elsner and Hammond. I specialize in contracting and land use, but also, do a little bit of everything. So you asked for a presentation on public meeting law changes coming up in the next year and the impact that might have on the city. So the main public meeting law changes that we would like to discuss are House Bills 2805 and 2806. Although those have applicable effective dates that are this year, the main impacts of them will be felt in the coming years. So first, as a note, I did provide you with a public meetings handout that incorporates these bills. And this is an example of the type of document that we would provide you if you were our client, and that we do provide regularly to our clients throughout the years. We also provide regular legislative roundup email blasts, which are just kind of updates on any legislative changes that have happened throughout a year that might be relevant to our clients. So House Bill 2805 has an overall effective date of September 24th, 2023. The bill first modifies into statute the case law concept of serial meetings. So before this was just in case law. Now it's actually in state statute. Public meeting is considered a meeting if the governing body gathers in a physical location, uses electronic video or telephonic technology to communicate contemporaneously, which means in the same time or same place, uses serial electronic written communications, so that means over a period of time, not necessarily all at once, or uses an intermediary, so a third party, to communicate. There are some exceptions to this. Meetings that are purely factual or educational in nature are not related to a matter that could be reasonably foreseen to come before the governing body for deliberation or a decision, or are non-substantive in nature, do not trigger this requirement. And ideally, this won't have a huge impact on you because you would have already been aware of the case law, but it's still really important to understand that it's now officially in state statute. Another aspect of this 2805 is the Oregon Government Ethics Commission, OGEC, now prepares an annual training on public meeting requirements. And every governing body member of a public body that has an annual expenditure per fiscal year of more than $1 million has to attend these. So I believe that you would qualify for that. And so that would have an impact on your city. Also, there are sections of this bill that expand OGEC oversight of public meetings laws. And there's a lot to that, but in relevant part, now you can, or one can bring originally a complaint of an executive session violation, and then OGEC could investigate, but now OGEC can just simply investigate of their own accord. So it really, paves the path for OGEC to investigate anything that they might consider to be a violation. So this would have, I believe, an impact on you. It just really simplifies the path for OGEC complaints. And it's important to understand because it could personally impact individual members of the city's governing body. And then finally, House Bill 2806, which was effective upon passage. This expands reasons that the governing body can call an executive session. That's under ORS 192-660. As I'm sure you know, there's a list of different situations when you can call an executive session, but now there's 2 more. Those include the ability to consider safety matters of the public body, staff, or volunteers, or any location that you're meeting at. And then the final one is to consider matters related to cybersecurity infrastructure or responses to cybersecurity threats. So it's just important to understand the very specific instances you can meet for executive session because they are very specific. So adding to will have a large impact on your city.
Excellent. Thank you very much. Appreciate that. So what we have 6 questions and we're going to go around the room, and those of us in the room are going to ask those questions just round robin one at a time, and you have 40 minutes to cover those 6 questions. So we're just going to get started with Dr. Lehman.
Sure. Trained this time.
What experience does your firm have handling construction contract disputes and litigation?
So I'll just take it and then I think I'll take, your questions and then field it if necessary, but I think our firm has a large variety of experience with that. David Dukeman and I specialize in public contracting and also the unfortunate, inevitability that some of those are going to go wrong and we're going to need to deal with those consequences. So David Dukeman does have, I think, a history of taking those kinds of cases. I've done some litigation, some contract litigation, and specifically construction contracts at a prior job, not directly at Barry Elsner and Hammond, but I do have some experience in that as well.
Yeah, and then just to follow up on David's experience, because I don't know that we've actually had many in recent years, which is, not what that's saying. But we have gone through the entire process, whether that's, depending on your contract, most of them have arbitration clauses, some will end up in litigation. We've done both. In most situations, they honestly end through mediation. Very few construction contract disputes actually go all the way through. There's just too much money on the line and the contractors are waiting for that money to come in and they need that money to basically move on to the next job. So most of the time you're able to settle those through mediation and we've been very successful at that. And that's honestly the best end product for our clients in most situations to be able to do that, because it saves you a lot on the legal fees and it resolves the situation, allows you to move on as well. But there's times where, the contractors are just unreasonable and you've got to go through the arbitration, you've got to go through the litigation. And we've been highly successful in that regard as well.
Alrighty. Second question. Please give an example of where you have provided balanced legal advice where differing sides of an opinion are at play. And we're talking about mainly about the city council differing of opinion between that's discussion.
So competing opinions.
Yes, correct.
Hardly ever happens, but.
Let's all get along. Maybe we don't want to work with you.
I feel like that's pretty. But I have a city who is assessing their storm water approach and currently considering whether they want to continue to do HOAs or whether they want to move towards, one unified system within their city. And it's really a cost benefits analysis that can get very complicated for them. And I think sometimes, it's easy to defer to maybe the legal voice for an opinion. And I think it's really important to be able to objectively give different perspectives, different legal perspectives, but not take a side and continue to be, that third party voice in the room to really just objectively show, here are your options, here's the legal risk, but ultimately it's your decision and your call. Do you want to get any examples for you?
I had one a few years ago that was a very high profile news media coverage and recall petitions against some city councilors, resignations as well, where essentially the community was very cared very much about an issue, and the city council, as unfortunately sometimes happens, had divided into two camps. They didn't see eye to eye, and there a lot of the time in those public meetings, when a difficult situation arises and those two camps can't see eye to eye, they try to bring the city attorney into the middle of it, and depending on what your answer is and whether it ends up benefiting one side or the other, sometimes they feel like you're their guy and sometimes they feel like you're in the other people's pocket, and that can be very difficult to navigate. But I find that by consistently giving the best legal advice and neutral legal advice, and so it's not always one side or the other that's feeling slighted or benefited, that eventually you have that credibility build where they see you as a neutral, independent party, and that helps then your legal advice have the intended effect where both sides can give it credibility.
One thing I think is important to add is At our firm, we take pretty seriously that our role is not to be the policymaker. You know, this is your community. We're here to help you make the decisions that are best for your community. And you're the ones who live here. You're the ones who understand what's best for your community. And it's our job to outline the risks on all your decision and say, you know, make sure you make this decision with your eyes wide open. And there's times where you're going to say that risk doesn't make any sense. And there's times you're going to say, yeah, we absolutely want to take that risk. And whatever your decision is, it's our job to defend that decision the best we can. And as long as we're giving you the information so you can make, again, that decision with your eyes wide open, then we've done our job. Now, certainly there may be situations where we're gonna have to tell you, that's absolutely illegal, you cannot do that. But it doesn't mean that you're gonna listen to us. And if you don't listen to us, then maybe we need to talk about it, is this relationship really working? But in 99.9% of those situations, that's not the case. And then it's just our job to say, look, you know, here's our advice. And the ironic thing is we have clients all over the state who take vastly different views on issues that are common to cities. So, you know, some recent examples are, you know, when marijuana was legalized, there were cities who are our clients who absolutely wanted to legalize it, wanted to collect as much tax money as they could from it. They thought that this was going to solve a lot of budget problems. They were all for it. We had other jurisdictions that were on the complete opposite end of the spectrum and didn't want it anywhere near their city. And our job was to explain to both of those clients how you achieve those goals that you as the council or the city manager decide is the best interest of your city. Camping ordinances are very similar. Cities are taking vastly different approaches to camping ordinances. And again, it's our job to outline, okay, here's your options and here's your risk, and then work with you on drafting an ordinance that made the most sense for your particular community. And that's a role that we take very seriously in sort of understanding that. And there's absolutely situations where, you know, staff or the council will look at us and say, well, what do you think is the best policy decision? And if you ask us, we might tell you, but at the end of the day, we're going to remind you that you know your community better than we do. And even for those jurisdictions, you know, we have clients that we've worked with for 30, 40 years, you know, going back to some of the main predecessors of our firm, you know, clients that we've had since, you know, I've been at the firm for 14 years or 13 years now. And, you know, those clients are still the same clients that we've had since day one. And you build these long lasting relationships with people and they want to know your opinion. You know our community really well. You've been here a long time. What do you think the right policy decision is? And we'll share that if we're asked, but at the end of the day, we really try to get them to make that decision because it's their community. And our job is to help you make that community thrive in the way that you guys see best fit, not the way that we think is best.
Just provide you the structured tools and the path forward to, you know, find your vision.
Excellent. Thank you so much. How would you describe your negotiation style and methodology?
One for public contracting. Well, I feel like because I, really enjoy public contracting so much, and also that's, one of my areas of expertise, I tend to approach all my work more with the idea of legality and understanding that, you can probably find some common ground. And for cities, really, I feel like it's the important thing is the end product, the result, so much, you don't have to worry about cost and profit. So I think because of that, it's such a good opportunity to be able to really build those relationships and those longstanding relationships that you'll probably be coming back to over the course of a career, whether that's with developers that cities work with over a variety of time, or whether that's other public entities or public agencies. So I think that that's typically my approach is, if we can find common ground, but at the same time, understanding your clients' hard lines, and being willing to compromise to an extent, but also, understanding where that compromise ends and where, the hard lines need to be drawn.
So,
okay.
I was just gonna add. So I enjoy litigation, and so that's where my mind went when you said that, is sort of how to I think that our strategy is that we are very reasonable in litigation, but we also aren't afraid to go all the way to the court and to fight through pleadings and arguments and even appeals. And so we prefer, the outcome to be
good right away for the client, but we're not afraid of a fight as well. And so I think we keep that in mind when we negotiate, which of course, as I said, we are always trying to be reasonable in every negotiation we go into, but with keeping in mind that we're not afraid.
And I would sort of echo what Emily was saying and emphasize one more aspect of that is in our negotiations, we also work directly with the clients to sort of, again, outline options and have a better understanding of exactly where you're going to draw that line. Because again, it's not our line that we're drawing, it's your line. And so a recent example, Emily and I were negotiating a litigation issue and a potential settlement with someone. And the other side came forward with this proposal and we were able to negotiate what we thought was a good deal. But then we went back to the client and we said, okay, here's this option that they're proposing and here's why we think it's a good deal. But here's your other options if you want to, counter with this or you want to go with that. And without getting in details and violating the attorney-client privilege, just outlining those options again for them and saying, where is it that you want to draw the line here? How much risk do you want to take? Because again, at the end of the day, it's the city's money, it's your money that, we're dealing with, and we don't need to spend, extra fees on legal costs, when the deal that's being presented is acceptable to you. And so we just want to make sure that, the way we're negotiating reflects what you want. And if you need us to take that hardline approach, we absolutely take that hardline approach. If you need us to get to a deal, then we get to the deal the best way we can and protect your interests in the best way we can.
I can add one more thing from the litigation side of things, which for me is land use. I think my approach there is just to try to be the most knowledgeable person in the room, if I can be, from a legal perspective. And so often in land use, that comes down to the really procedural minutia, those like tiny little details. And so much of the time, that's what's so important for public clients, and what the appellant attempts to trip the local governments up on. So just really being familiar with all of those factual details and all of those procedural details, just, having them know them like the back of my hand, that I think is a really important approach, to negotiating.
This is Counselor Andrade. You've been driving from the airport.
And I'll just add one last thing. One thing that I've found in negotiations in different contexts, whether it's with the developer at a land use stage or labor negotiations, it's really easy to get caught up in positional bargaining, where one side's putting forward a proposal and another side's putting forward a different proposal, and you're just talking about the proposals, and it seems like there's no common ground. And to go one layer beneath that and try to understand the reason for their proposal and the reason for the different positions, sometimes you can come up with an outside the box solution that achieves both parties' goals. But it seemed like it wasn't even on the table.
Thank you so much for that. Appreciate it.
Thank you.
Next we have Counselor Causey.
Provide an example of a home rule challenge and how you might advise a municipal client.
Yeah.
So I'm our resident, I guess, charter geek. For whatever reason, this is an area that I really enjoy. It probably started way back when I was at the San Francisco City Attorney's Office, and then when I was a general counsel for the League of Board and Cities, it certainly was a main issue that we worked on at the League and continues to be a main issue that we work on at the League. So there's a lot of examples related to home rule, whether that's protecting home rule at the legislature. One of the issues that we've been dealing with a lot lately is the transient lodging tax issue for a lot of our clients and sort of the preemption that exists there. Another really interesting issue that's come about lately is related to guns and gun control and the ability to regulate guns and public buildings, whether it's municipal court, school buildings, working with our school districts and our school resource officers and what they're allowed to do. It comes up quite often, and we've often dealt with it in litigation. One of the things that our firm does a lot is we work with the League in drafting amicus briefs, which are the Friends of the Court briefs for different jurisdictions. And we recently helped out the city of Portland with their rent control ordinance and home rule there. And Emily wrote a really strong brief to the Court of Appeals that we actually ended up helping the city of Portland win on their home rule case there. And there's a preemption language in state law related to rent control, and Portland has passed all these renter protections that weren't specifically rent control. And the landlords in the city challenged that and said, well, that violates the home rule rent control. And so we were able to help convince the court that that wasn't preempted by home rule. And so it's one of those issues that, you know, I could probably have a long list of examples. But it's one of those issues that I think is primary to what cities have to deal with. And we're very fortunate in Oregon, unlike a lot of cities across the country that are general law cities. They don't have this home rule authority. So any authority that they get derives from the state legislature. And anything they want to do, they go back to the state legislature and ask them to do it. And if the state doesn't like it, they just come in and preempt them. We're very fortunate in that we, you know, have a certain amount of home rule authority, and the courts have interpreted it pretty broadly. And so it's part of what's really inspiring about the jobs that we have is that we get to, what I call, participate in the laboratories of democracy. We get to work with clients on these ideas of things that they want to do. You know, it may be outside the box, and can we, you know, do this or can we do that? And it's so fun to say, yeah, you can use your home rule authority to do this because you're not preempted by federal law, you're not preempted by state law. So you can do this, and we can draft something and create something that's brand new that may take off in the rest of the state or the rest of the country. And you may like really change the way something works or something happens. And, you know, a great example of that are local improvement districts. You know, that all started at the local level. A local improvement district, if you don't know, is something where entities and property owners can get together and basically tax themselves to build an improvement, whether it's a street improvement or a sewer improvement or some sort of infrastructure improvement. And that all started because someone had that idea at the local level and said, hey, we should be able to do this and impose a tax on ourselves and pay for this. And now it's something that's widely used all across the country to be able to improve infrastructure in a particular area for a specific property. And so that's the kind of thing that, you know, we find very inspiring in our office, that, you know, you get to do these things and work on these issues with people who care about the community so much. And, you know, it's sorry to geek out on you, but it's just one of those things that is really enjoyable about our jobs. And, you know, I honestly think in talking to elected officials all across the state is why a lot of you volunteer for this job. And these aren't paid positions for you. You're volunteering your time, you're coming in late at night like this. And, you know, you're doing it because you care about your community and you want to like come up with these creative ideas. And to me, that's why home rule is so important, because it really allows you that flexibility to do those things.
Thank you so much. Councilor Crocker?
Yes, describe your firm's experience working on a topic relevant to urban renewal agencies.
Well, I think we have a number of urban renewal agency clients. I have handled a number of minor and actually almost one major amendment too for a particular urban renewal agency that I can think of. I think we're actually one of the only firms, I believe, who specializes in urban renewal agencies. And so I think we do have a breadth of knowledge in the statutes, just experience working with cities and separate agencies when they decide to do that, reviewing plans, amending plans when necessary, interpreting plans when more necessary. Yeah. Do you want to speak to anything, Chad?
Yeah, so we, as Ashley explained, we represent a lot of both for those clients of ours that are full-time clients, but we're the city attorney, as well as urban renewal agencies, but we're not the full-time city attorney. So for example, the city of Astoria, their urban renewal agency hired us to be the urban renewal agency attorney, when we're not the attorney for the city of Astoria. And we do, you know, the full breadth of work for urban renewal agencies, except for the bonding stuff. When you want to talk about your financing, your bonding, you still need to use bond counsel. I mean, that's a highly specialized area. It's really important that we work closely with bond counsel. And we have very strong relationships with most of the major bond counsel in the state. So it's a really great relationship to be able to work in conjunction with them. A lot of what we do, from whether it's the formation of new urban renewal areas, major amendments or minor amendments, we've done all of that. But most of what we do come in two different areas. One is real property transactions, so negotiating, purchasing, and selling of real property for urban renewal agencies. The city of Hillsborough is a great example of that. They have what they call it an industrial renewal agency. They sort of created this new term, but they did something really interesting where they basically had a lot of greenfields, you know, not your typically blighted areas, what you're looking at for urban renewal. A bunch of greenfields, old farmland that had been designated as industrial lands. but there was no infrastructure to actually attract industrial users. So they were able to basically call this blighted under the statutes because they didn't have the infrastructure necessary to support the designated land uses. And so we were able to use the urban renewal statutes to get money, purchase land, aggregate land, and then sell that land off to developers. And then also through that process, make some money to help build the infrastructure. So it's a really great use of urban renewal because the tax base basically went to land that was in farm deferral, meaning it was getting no property taxes whatsoever for all the various taxing jurisdictions, to industrial uses, which now have a very large tax base. So it's actually one of those examples of urban renewal working at its best. And so property purchase in there, and then also just development agreements. So when you buy the property, that's one side, but on the flip side, when you're selling the property, you're not just selling it like a normal property transaction, you're doing a development deal because you want the property to be developed in a certain way. And the urban renewal statutes actually have certain requirements about when disposing of land related to urban renewal, that you have to put certain restrictions on that land. So working out those development agreements with the various developers about how they're going to develop that land is also critically important to make sure that there's success in the system. So those are probably the two primary areas, but there's lots of other examples, you know, the storefront improvements, grants that people give out, other sorts of grant programs, some great art programs, you know, public art programs that we've used urban renewal funds for. So, you know, lots of various types of contracting and programs that we help our clients with. And again, it's a pretty fun when it really sees the increase in taxes in the urban renewal actually working like it's supposed to work. It's pretty satisfying.
Excellent, thank you. Can you describe your firm's approach to balancing the needs of small municipal clients versus those of larger municipal or county governments?
Well, from my perspective, I think your Chad's point about it all being a team, right? We can approach, we can use what we learn with our large clients who might have the resources to pursue maybe like the camping ordinance, right? The camping ban, and really research this topic and really flesh it out. And this ends up benefiting all of our clients. You know, we have this all sorts of clients, you know, a variety of populations, a variety of types of public entities, and really everyone is in the same boat and experiencing the same issues. So because of that variety, we're able to really reach across the aisle and have everyone benefit, and just benefit internally from all the different experience and backgrounds and expertise that we all have, so that we can share our knowledge.
Yeah, to echo that a little bit, I was previously an in-house attorney. So I was in-house for county government for 4 years and then in-house for city government for 7 years. Lots of pros and cons between being in-house and outside. Of course, I love working in the but one thing that I do really enjoy, because it's satisfying for me, but also see the benefit for my clients, is when I was in-house and a new issue comes up that I haven't seen before, or like legislation happens that's going to impact cities, I have to spend all the time to get up to speed on that and deal with it once, and then I'm done. And now here, when some issue like that comes up, I spend that time getting up to speed on it, and then all of my clients benefit from that knowledge, the legal knowledge, but also from the experience I have from working with all these different clients who have different approaches. So I can provide sometimes perspective. People say, well, what are other cities doing? Well, I can say some clients are doing this, some clients are doing that, and if you want, I can send you examples from 3 different cities that have 3 different approaches, so you can consider those. I think also maybe part of the question was about balancing the needs and demands of those different clients. And I think Chad's point earlier in his introduction about how we structure the firm, where it's a team approach, but we also have a primary attorney or 2 primary attorneys for each client, really helps with that, because you're not trying to get the attention of somebody. You have somebody who is dedicated to providing you your attention. So you're not competing for all the attorney's attention against all the clients. You have that direct line of communication open.
It's going to sound a little cheesy, and I apologize for that, but it is sort of like a family, and our clients almost treat each other like a family in a weird way, because they all know that we're busy with various clients. And it's not really the size of the client or the level of importance of a client that makes the difference. It's the immediacy of the issue a client is dealing with. And as you know, every city has a situation where some big emergency is happening. There's something that needs a lot of attention. And if that means 4 lawyers from our office have to immediately drop what we're doing and work on that for that particular client, we do that. And our other clients all get that because they all understand there's a synergy, like Josh was talking about, between sharing the resources of our firm and getting the benefit from each other. But they also understand that, like, when it's their turn and they have an emergency, that all of our attention is going to be focused on them. And so they're willing to say, okay, well, we're willing to wait an extra day or so to get this work product back from you because we know that you had this emergency for this other client. And it's, again, it sounds a little cheesy that like all of our clients sort of like work together like that, but in a way they do. And you see it like when you go to the LOC conference or you do those sorts of things and our clients are all sort of talking together and they, it's a really nice sort of feeling to have. And knowing that I can tell someone like, oh, I've got this other emergency for this client, so I've got to like push yours back. And, people understand. And if not, then we make sure that there's someone else in the office who can work on that particular issue. And the other thing that I just want to stress is that it's not just your lead attorney working on an issue. What we really try to do is make sure that you have the person who's the expert on a particular issue working with you on whatever that is. And we do that for 2 reasons. One is because we think you get better legal advice. And I'll use land use as an example. I can do land use law. I've done land use law. I've done LUBA appeals. I've advised planning commissions. I've advised city councils. I don't like land use law. It's just not my cup of tea. I may geek out on charters, but I do not geek out on land use law. And so for me, if I get a land use question, I've got to go back and I've got to like look at the statutes. I've got to look at your local zoning code. I've got to like take some time to figure it out. Where, Josh or Ashley or Chris Green or David in our office who really do enjoy land use law, a lot of times they can answer that question off the top of their head. And so they can do that for you and you're going to get better legal advice and you're going to get it faster and cheaper than if I work on that issue. So we really try to make sure that you are getting, the right person to do the work for you. And what that means is that the work is spread out among all of our attorneys. So if one attorney is really slammed because they are the lead attorney for 3 clients and all those clients have big issues going on, it doesn't mean that that attorney is the only attorney who can work on that. Because that attorney will then say, shoot an email to our office-wide email and say, I've got this big issue for Hillsborough. Can someone work on this issue for Cornelius for me because they need this back today? And then someone else will jump in and work on that issue for that client. And that's, I think, one of the benefits of having a firm like ours that really just focuses on cities and the work we do for local governments, because we are pretty interchangeable. I like to think of myself as like, oh yeah, I'm this great attorney and no one can replace me. Any 3 of these folks and everyone else at our firm can replace on any given day. And that's, it's sort of that sort of base layer that you have of protection, knowing that if I go on vacation or if I'm out sick with COVID or whatever else the case might be, there's, 7 other attorneys in the office who can step in for me at any second.
Excellent. So we have a little bit of time left and I just wanted to offer 3 different options here. You can revisit any of your questions that you'd like. You can ask any questions of us that you may have, or you want to share any other information you accept.
We did ask one final question. I wanted to make sure I asked of you. Related to Zoom meetings, is this typical for smaller cities, or just discuss that a little bit? Our current city attorney is in Corvallis and comes to all of the meetings. So it's a little bit of a transition, but we did ask that question of the last firm. So I just want to give you a chance to talk about that.
Whether attending Zoom meetings or seeing Zoom meetings.
Yeah, and just how common is it? Kind of reassurance, because it's so different for this council and staff. So just that topic.
You're winning this cool technology in your ceiling. I've never seen that before. But yeah, I think I see it fairly often after COVID. So many people went that direction or were required to for a period of time. And now we have clients all around the state. And especially I can think of in the Columbia River Gorge, where we don't attend their meetings regularly in person, but we attend via Zoom. And, we can have either captions on if it's ever an issue of, clearly reading what someone's saying. But otherwise, I don't see an issue with that at all. It never seems to be an issue. I can raise my hand during the meeting if I need to interject or make a comment, or I can simply unmute myself. I think, just being a main, what's it called? Just like a main participant, gives you the ability to be able to do that.
I would say, our clients run the full spectrum. I have a client that wants me in person at every city council meeting, every time, whether there's something on the agenda that I could be asked to talk about or not. If it's, just appointing a new police officer and recognizing somebody for the parade that's coming through town, and there's no legal issues whatsoever, they still want me there, just in case something happens. We have clients who don't even have us attend by Zoom every city council meeting. They only have us attend if there's something that they think they need an attorney for. And then we have everything in between. Clients who want us there by Zoom every time, or Zoom as needed. Sometimes it also, it depends on the meeting too. Not like you have to make a decision at the beginning of the relationship. That's what you're going to do for every meeting. If you have a really heated topic or a lot of conversation you expect to go back and forth, and maybe you have somebody come in person when you would normally have them appear by Zoom. Really a preference and comfort level. But I would say that the overall trend is towards having us join by Zoom rather than in person. And that's, I think, primarily a cost and efficiency decision.
I'm also finding that, and I think I emailed you a little bit about this, that when we do it remotely via Zoom, clients can sort of pick and choose, okay, you're here for this part of the meeting, and then we're gonna let you go. And it's not as big of a cost factor when you have us come down, and when we're here, you just have us sit here, you already paid for us to be there. But when it's via Zoom, you have us attend for the first half hour of the meeting, or you have us sign on an hour into the meeting, and you're only paying for us when we're there, and it's a lot more cost effective. One of the things that we really try to do is work closely with our clients to sort of figure out how can we provide the most cost-effective services for you. How do you get the most out of your legal budget? And I know, I had a lot of conversations with your current city attorney, who I think the world of, by the way, and I think I'm equally disappointed that he's retiring as you are. I mean, he's been a great friend and a great mentor for a long time, ever since I moved to Oregon, and he's going to be missed. But we talked about sticker shock. I think you used that term with you guys, and just the difference of the transition you're going through. And we had and Emily can talk about this a little bit. We had a very similar situation with the city of Seaside, who we recently became their city attorney, and they had another longtime city attorney who retired. Very similar situation that Jim has with you all, and it's a transition, and it is a bit of a change, and you need to rely on staff, and we work with you to make sure that your staff has the capability to do things. And we're here for you whenever you need it. And the one thing that we do is that we have that lead attorney that's assigned to you, and that attorney puts on their calendar, this is your meeting date, and they reserve that. So it's not like they make plans to go to another city or something else like that. So you decide, it could be the day of, and say, yeah, we decide we need you. Like this big controversial issue arose in the public, and we're gonna have 20 people show up for public comment. We really want you to appear via Zoom, or we want you there. So we have that day and time reserved on the calendar, so you'll always have an attorney available if you need it. And if you don't, great, we can go spend the evening with our family, we can have dinner at home, or whatever the case might be. But if you do need us, we're there. And so it's not like we're asking you to make a decision well in advance. We're there for you if you need us. But at the same time, I can't tell you how many Eagle Scout presentations I've sat through, or state legislative updates, or the first act of the community play where they come in and perform for the city council. And it's great. I love it. I love being a part of the community and seeing what's going on. But if I sit through an entire council meeting and I say, hi, everyone, and I say, bye, everyone, and that's the only thing I said, that is not a good use of your legal budget, at some point you get asked, can you charge us by the word? Because it's like, I'm not doing anything good here for you. And so we work really closely with staff and with the council to say, how can we make sure that you're getting the best use of your legal budget?
Yeah, I would just add to that, that I feel like the flexibility there is really important, right? You know, we have the ability, and we do with a lot of our clients, to be able to attend virtually, but then also, like Chad said, when it's needed, like an executive session or even like a work session where it's important we're all in the same room together. Yeah, there's never an issue. Like, I feel like you can be flexible and have both.
And one of the things that we put different references and we sent some more references for you all today. But one of the reasons we put the city of Sutherland down as a reference is they've been our client for a long time. They're down in Douglas County, which is several hours away. And when we first started working with them, they would have us drive down, and it's a long drive. And it wasn't always a good use of their money. And so even before the pandemic, we started using Skype to Skype into their meetings. And at that point in time, we were the only person on Skype, because it was just one-on-one, but we would appear via video conference. And I think they would be a great resource to talk to about sort of how that situation worked. And then, the gamut, from the largest city of Hillsborough to all our very small clients, they all have been using Zoom. And, other than the occasional Zoom bombing issues that we've all sort of had to work through, it's really run seamlessly.
Excellent. So now we have 3 minutes left. If you'd like to answer any questions of us, great time.
Yeah, what would you consider to be the biggest challenges facing your city right now?
Executive session? Generally speaking, I think the transition that we've already touched on a little bit, and just, we need to talk about our policy on interacting with the new city attorney, and what that's going to look like. So I think that's maybe not huge, but it's front and center right now. And so just that issue, we do have some contract litigation stuff that we're looking at that's pretty big, dollar figure wise. And so we've got some serious concerns there with some infrastructure projects. So that's pretty big right now. Certain council members tell you that home rule is a continual drum that we need to beat and continue to push against, and I don't disagree. So, I think our council is becoming more aware of, growing up and being a little bit bigger and maybe a little bigger population is dealing with things we didn't traditionally have to deal with, things like camping ordinances for homeless populations, and things like being more involved in the legislative process, and looking at how we can support the league, but also regionally, how we can support needs of the city locally, with our state legislatures and things. So, there's lots of little legal issues like that pop up, where we may be looking to the city attorney to give us some legal opinions on things, or, even process wise, best way of getting things done. So I don't want to minimize it. There's lots of little things that are kind of front and foremost. There's definitely some big consequence type decisions that we're gonna need some legal counsel on pretty quickly, like yesterday. But for the most part, the city's been well run and well managed. We've had good legal counsel supporting us, and I don't think you're gonna find you'd be taking on a new client that's in arrears in any way, or back in the dark ages. I think we've been pretty cutting edge and pretty forward thinking, and there's a lot of good things happening in town, but that brings the need for good legal counsel at times. So did I sum that up for you?
Very well.
You didn't notice your evaluation.
Yeah.
It's 2 weeks.
Thanks for the reminder.
Any last question?
I just would like to thank you all again for having us. I think one of the things about the folks in our firm is that, we all, for whatever reason, have fell into this line of work because we really enjoy it. We sort of view it as community service. I think all of us have the legal skills and background and expertise to be working at bigger firms, making a lot more money than we make, but it's not the same level of job satisfaction. There's nothing like going to a community event and seeing something that you've worked on, whether that's some sort of development, a new library, Hillsborough is a great example with the Hillsborough baseball stadium out there, and helping bring that team to Hillsborough. And then you go to the game and you see like these families enjoying the game, and that you played a role in that. And there's just a certain level of job satisfaction that you get out of that, which is why we do this job and why we love this job. And those are the kinds of things that we hope to be able to help your community continue to do. And we know that in sort of reviewing everything on your website and reading through your minutes and watching your council meeting videos. We've seen a lot of the good things that you've been doing. And I think it's a really fun community. And, you know, when Jim called and asked if we'd be willing to sort of put our hat in the ring for this, and we thought about it because, you know, we've got a lot of clients, as we've talked about. And, you know, just knowing that you've got this successful background and the great things you've been doing is what makes us excited for this. So we just want to thank you for the opportunity to be considered. And if you have any follow-up questions afterwards, please feel free to reach out because we'd be more than happy to answer them.
Excellent. Thank you so much for being here. Appreciate you guys.
Yeah, thank you.
Yeah.
Where are those restaurant recommendations?
Safely.
On that.
Yeah.
Yeah.
Break. Yeah, we'll take another break.
Come back at 8. Just in case they come in. Thank you.
That was a long time.
Yeah, that ceiling.
See the new lights.
It's the people that care.
Okay. So thank you very much. So now we have Ivory Miller and Masri Clark. And I just want to tell everyone, so we have 10 minutes for a pre-introduce yourself, welcome, and then to discuss a short presentation topic. How does your firm balance economic impact on the city and fairness to defendants? Before then, we will go into, we'll have 40 minutes set aside for 5 questions, which we'll go around and ask. But really appreciate you being here, and we'll go ahead and let you introduce yourself.
Good evening. Thanks for hosting us. My name is Dan Miller. Good to see some of you again. I was in Catherine's role years ago, 8 or 9 years ago, as the deputy city. I really enjoyed my time in Philomath, and then went out into private practice. And one of the things I maintained doing was keeping my neck here, and I went to the other side with defense counsel in the municipal court because I enjoyed appearing there. When we had the opportunity, because I got to work with Catherine in that role to bring her on as a member in our firm as an attorney, because of our admiration for her work and how we enjoyed working with her. And then when this opportunity came open, with both of us having served in the prosecutorial role and liking working with the city, with the former police department, and just really kind of an enjoyment on our part of the municipal prosecution, what that means to a community like this, and being able to fit that role was something that we wanted to jump on and have the opportunity to do. So we're grateful for the opportunity to be here and present what we do for that. I've been an attorney now for just about 10 years, coming up on that now. Again, a little bit of it, 2 to 3 years in city practice with was Fuel Brewer in Coulomb at the time that I was there, and then transitioned into private practice, right, in mostly family law with a little bit of criminal defense. So that's still what I'm doing here today.
And so I know most of you through my position as the prior deputy city attorney for the city of Philomath through the firm Brew in Coulomb. And I functioned as the city prosecutor when I had that position. I really enjoyed it. That is how I got to meet Dan. Dan and I have had a jury trial against each other in municipal court, and getting to know him through that position, and also talking about the experience that he had when he was in my shoes. We kind of developed a really nice relationship, and so that is in part why I did end up going and joining his firm. That and I know other attorneys in that firm, and there is a really good work ethic in that community. And part of the discussion, though, when I was getting ready to potentially transition there was, as Dan explained, there is some private practice and there was defense work, including in this municipal court. And we, crunched the numbers, ran all the names that would be people that I prosecuted, people that Dan's defended, all of that stuff. And there's minimal overlap in terms of now that Dan has stepped away from defense work, which was a plan kind of step away prior to me coming on. It doesn't put us in a position where we are going to be limited in any way to take on that prosecution work. It hasn't happened recently as far as I'm aware, but there are times where there are things called a conflict where an attorney can't either represent a party or potentially prosecute, defend, whatever you have, because they have a conflict related to a prior engagement with that person as their attorney. And I just wanted to make it known that that's not going to be an issue, despite the fact that Dan did defend and that we do have other attorneys that have their private clients. So just making that aware to you guys, so that putting off that potential issue or potential concern. The other thing, going to you guys' question with respect to balancing economic concerns for the city versus, the public concerns of criminal justice and making sure that assistance from achieving possible, but also in the way that serves the highest number of people in the best way. Part of my philosophy as the prosecutor in my prior role was that when I'm gonna, make an offer to a defendant, so when they come in, they have their arraignment, they will whether or not the city is going to, prosecute them for a particular charge or a particular crime that they received a ticket for, they might have been like alleged that they committed. I'm coming in with the idea that I'm going to make them an offer that is the offer. And essentially what it says is that either you can take this offer or we can go to have a jury trial or whatever you want to have. The reason I do that is because I don't want to punish a defendant if they want to go and talk to a defense attorney. The idea being that the way that the position functioned when I was in my prior position as the prosecutor is that I would show up at a criminal arraignment and talk to the defendant before they even ask the court for a defense attorney to let them know that it's a way for them to potentially save money, because even though if you are appointed a defense attorney, if the court finds that you're able to pay a nominal attorney fee, which is usually around what, $300, $250, depending on how much work.
Yeah, anywhere from 150 to 350.
It's something that can be an additional burden. And so I think that it's incorrect essentially to approach something where if I'm going to talk to someone and they're going to get an attorney and then they potentially have that additional burden, then I don't want, I'm trying to go in and let them know that I'm not going to say, if you go talk to an attorney, this particular offer I'm making is going to go away. And so it kind of lets them know that I'm here, I'm not, potentially going to, I guess, waiver as things get closer to trial. But it also does though is when as I've talked to Dan about it, since he's been on the other side where I'm making offers to him, when I've established relationships with our court appointed defense attorneys, they also know how I function as a prosecutor. And so they're able to also, if you establish that pattern, then the defense attorney can also, help along a case to get to the end, whether or not that's going to be a plea, a jury trial, or, something else that could come down the line. Because there is a chance that, as we go through discovery or whatever, the case could get dismissed. It does happen, but that's not, the goal for me as a prosecutor, unless that's, I can't prove that particular crime happened. And again, part of the reason that's important is because every time that I'm in a courtroom or we have police officers that are, going through their body camera footage, editing it out so that we can produce it for discovery, having the court appear and having them, administer all of these cases. It's time and it's staff time, personnel time, every time that someone has a court appearance or every time that we do particular things. And so the goal, being that if you can establish a pattern so that we're trying to get cases moved along as quickly as possible, that's for the best for everyone, because there's the criminal justice component of if someone, makes amends, takes accountability for their actions. And a lot of times what I ask them to do is get back to the community. So I usually ask that they do community service as opposed to paying a big fine or going to jail. That's not something I like to do. So asking them to give back in that way so that way, they can potentially help themselves too, because a lot of times people are in a situation where they are either in between jobs or they're under employed, and so potentially getting them that opportunity to make those connections to go and get additional employment. Because a lot of times also, because I'm here in court when we have people appearing for failure to make payments, speeding ticket or other kind of traffic violation, if we can balance hey, if you can show that you can do this community service and you've done everything that you've been asked to do, but you still have money that you need to pay, maybe we can work with you where you can do more community service and we can take off parts of your fine from that. And, having the flexibility to do that is something that I found has been especially helpful, and that the current municipal judge, Judge Blake, is really helpful and supportive of doing, because this is a small town. There are, a lot of people in here that know either the judge or the court staff. And again, as long as people feel that there's an accountability, that people are being held accountable, that there's some kind of, justice that's been done for people that do violate the law or, hurt their community, then generally speaking, we come to a satisfactory conclusion. So that's kind of how I've functioned and how I've, worked with our court staff, worked with our police, and worked with the defense attorneys to just move cases along. Because the worst thing is when there's a case that lingers for a year plus, and that was especially prevalent during the COVID pandemic when we were doing a lot of remote stuff because court was getting set back and people were sick. So we had cases that lingered for a year or two, and we had officers that retired or moved, and things just got really complicated. And so trying to move things along as quickly as we can is very helpful and important too.
Yeah, and all I would add to that just briefly is, and it helped me working with Catherine that as she said, indicated, she was firm on something, and her resolution to cases was always tied to the case. If there's an anger component to it, right, two people are fighting at a bar, you know, you're gonna get an offer that says, I want you to do something, you know, alcohol treatment related, and I want you to do something to manage your anger. And once you got in that flow and knowing how Judge Blake operates and what his expectations are, then it's easier for defense counsel to say, okay, we know what we need to do to work together to solve this problem. And she mentioned it, but I really want to highlight it. I think the other thing that's the benefit to the city and reduce costs is Catherine was one of the rare prosecutors I dealt with that didn't change her offer just prior to trial. And I think that's really important because I've appeared in other courts as defense counsel where it's known that you just say, let's set it for trial and we'll get a better offer right before trial. And we'll spend more costs prepping with the officers to having the court send out jury summons and do everything else. And then we'll get some easy deal right before trial from that prosecutor. That wasn't the case with Catherine. So you knew, hey, I'm getting the best offer up front. We should take this. This is good. We know what she's looking for. Let's meet her where that is. If we disagree, we go to trial. But you didn't play any games. And I think that really expedited how the process worked. And again, we'll save money, but also that's recognizing, that's giving the defendants the benefit of, hey, they can have counsel, they can get some legal advice. They're not going to get punished for doing that, but they're not going to get a benefit from trying to game the system. And I think the other piece that's important that we recognize is the preparation that goes into that prevents a lot of bad outcomes. So meeting with the officers ahead of time, going through reports with them, prepping witnesses and being ready to go. That again eliminates that unknown at trial.
And, voicing that, and Ms. Brianna Harwood's not here, but as the court clerk, I've heard, the conversations I've had with her we need to cancel trial. And so she has to call 40 plus people if they've gone and given back or returned their jury summons notice. And she has to call every single person that's responded and say, thank you for doing this. However, you don't need to, you don't need to come in that day. Since it's a much smaller court, they don't have the automated system like the circuit court where you just simply call in and they'll let you know whether or not you're there. She physically calls them, has to mail them out. It's a lot of prep work for her, and she needs to do that a minimum of 2 to 3 weeks prior to trial. That's another thing, trying to avoid clerks' extra work, because then when they can function well, Judge Blake can function well, and everyone is just rolling smoother. And so bringing the continuity, hopefully, if we were to be awarded this position, would be super helpful, because I know that there have been challenges recently or not even recently, but just like, for instance, when I came on, that hurdle of overcoming that learning curve can be kind of challenging, and it takes a while to get into the swing of things. And I felt that way, and I know that was expressed by the court clerks. I respect you. Dan had this position 8 years ago. I had it as recently as a month and a half ago, but in between the two of us, the 2 other prosecutors. So it can feel bumpy and this group of things, and I really enjoyed the position I have here, and I want to continue that, hopefully, for a long time yet.
Excellent. So we're 34 minutes left, and we have 5 questions. And we're going to go ahead and do round robin style. Councilor Andrade, would you be okay taking the first one since you didn't get the opportunity previously?
Sure. Tell us about your experience with municipal prosecution.
So I think the most recent trial I had in a municipal court was actually here. And it was a jury trial that we had in August. It was not Dan Miller, it was against Dan Armstrong, the other court appointed defense attorney that was on Judge Blake's list of defense attorneys while I was here. I think they've gone and got another person. I don't know their name right now, but anyway. So we had a jury trial as recently as August. It was a DUI trial, so a class A misdemeanor, which is the highest level that Philomath handles, and a reckless driving crime, which is also a class A misdemeanor. And I was able to successfully convict this person of both counts. And the reason that's kind of significant is because in Oregon, the legal limit's a 0.08 BAC blood alcohol content level, and this driver had a 0.04. And the reason he was convicted was in part because the way the tests were done, he refused to consent to give a breath test, and we didn't have his blood sample drawn until 3.5 hours after he was stopped. So we had to do, if you track back, you get to his BAC would have likely been around here, but even if you don't think it was, he still was impaired while he was driving. And, we ended up convicting him. But the reason I also want to tell the story is because this person was eligible for a thing called diversion, which is in Oregon, when you are a first-time DUI offender, you're allowed to enter into this program called a diversion to keep a DUI conviction off your record. It'll remain there. It'll say DUI dismissed diversion, and it's going to remain on there forever. But the reason I want to bring this up is because I really tried to work with the defense attorney to get this person to enter into diversion because he was eligible for it. And I thought that it would, potentially be helpful for that person. And it was also, again, a way to save resources for the court, because in reality, a diversion and a first-time conviction for DUI are very similar in terms of the punitive measures that are assessed. The only difference being, is there any jail time? Because you won't get jail for a diversion. You have to do classes, you have to install a breathalyzer if you were in alcohol, if you were using alcohol when you got stopped, pay a pretty significant fine and do a few other things. If it's a conviction, though, you potentially have to go to jail, or in my case, I'd have you do community service. So, trying to work with the defense attorney, trying to work with Judge Blake to at least have that person potentially do that. It was an example of us trying to work in, the small community where we had established the relationships between all of the moving parties, and didn't work out for him because he still ended up going to trial, and, he had his day in court. We, did the system as it was supposed to happen, but just wanting to bring that up because when you have those kind of relationships, you can try to be creative or potentially, get to a solution that involves the least amount of resources, but still, it's at the end of the day, pretty, it satisfies all the components of like criminal justice and all of those kind of things that everyone wants to feel good about at the end of the day.
I do suspect that maybe the question, tell us about your experience in municipal prosecution. Maybe you'll be good to summarize the depth of your experience.
So when I was with the firm Brewing Coulomb, I was working as the deputy city attorney for the city of Philomath, the city of Corvallis, and the city of Harrisburg. All of those cities have municipal courts, and so I was functioning as the prosecutor in all of those courts during the 2+ years that I was there. Corvallis has municipal court twice a week, every week. Philomath has municipal court about twice a month, and then Harrisburg has municipal court once a month.
Thank you. Councilman Moore.
How do you handle difficult cases where there's a lack of evidence or witnesses?
So that can be complicated in terms of, when you have a witness and then they decide that they want to recant or things like that. I've had situations like that before. And what helps me for purposes of, again, the criminal justice aspect, are there other charges associated with, so for instance, we had the person that had the DUI and he was driving recklessly. Let's say that I didn't have, I didn't feel confident on that DUI. I could potentially say, well, people saw you driving very recklessly, would you plead to that? Those kind of things, try to work with that. And if that's not available, there's another instance where I had essentially a neighborly dispute, and the Oregon statutes allow for a thing called a civil compromise, where if someone criminally wrongs another person under certain circumstances, it can be compromised in like a civil setting. And in this particular case, essentially, the neighbor that committed a crime gave the victim neighbor money. And it didn't really, in my opinion, resolve the problem. And it was a very unsatisfactory outcome for me, as you know, in the role of a prosecutor, but it made the victim happy. And what ended up happening at the end of the day was I had to dismiss the charge against this person because they met all of the statutory components to have it dismissed. And, you know, the victim themselves, you know, felt at the end of the day like they were, you know, they were done justice, you know, they felt good about it. I didn't necessarily think it was a good outcome because this person could, you know, I don't think that they necessarily learned from it. They just gave a lesser amount of money than they would have potentially gave back to the community and community service.
And just to add a little bit to that, I think the other piece that it addresses, what do we do if we feel we're missing evidence or we're unsure about our witnesses? Again, that kind of gets to that prior preparation piece. That's where it's, you know, having that good relationship with your officers, your local officers, so that you're, hey, I want to follow up. There's this gap in your report that I can't fill in. You know, I think, having worked on both sides, but more recently on the defense side, the Philomath Police Department writes reports in such a professional manner that it makes you don't run into that problem as often, because it lists, here are the witnesses, here's how to get in contact with them, here are the elements of the crime and what violates it. And that's not the case in every jurisdiction. I think that's taken some time with prosecutors, working with them, adapting after you have a trial, and making sure that you can address that. And again, that's recognizing, hey, we might have a problem with a witness or evidence well in advance of trial, not when you're showing up and going, whoops, my witness is not here. Again, knowing that in advance lets you take some of the roles you're gonna have or differently, rather than what I experienced sometimes going into places where, hey, it doesn't look like the attorney talked to their officer, and so they have a different timeline than the officer does. And then that's something that defense attorneys just attack in front of a jury. You'd rather have that preparation done ahead of time to resolve that.
And I think I've kind of taken for granted like that everyone knows kind of how the prosecution system works. So before I even show up to court, I get a copy of the police report, and 9 times out of 10, actually, well, more than 9 times out of 10, I also get a citation. So like similar to when you get a speeding ticket, but it's for a crime. And so what I do is I look and make sure everything on that citation is correct. And like that it lists everyone's name, their birth date, everything like that. And then I actually look at the charge and read the report and see if that charge is actually established by what's reported in the report. Sometimes I will have follow-up conversations with police officers or even some of the people listed in the report as witnesses or people that were interviewed to see if I want to actually endorse or go through and actually prosecute this person for this charge. And so that's kind of what Dan was getting at. There's a screening process that I will that would be gone through prior to someone even showing up in court. And so what's happened before, and I, you know, usually, or I made it a habit to talk to an officer before I did this, but if I was going to no action or not endorse a citation, I would talk to the officer and let them know why. Or in some cases, they would reach out to me and ask me to no action it, either because they felt, you know, after looking at the, you know, basically sleeping on it, that the situation wasn't as they thought it was, or they didn't feel strongly that the situation was, or the facts around it were strong enough to support this particular crime. Or in some cases, they wanted to send it to the Benton County Circuit Court, to the DA's office. And so they would ask me to no action it here so that they could send it to the other court. So that's prior to even showing up in court. And then once we show up in court, I've already done that prep work. I've got an offer for that person, and then potentially the defense attorney gets introduced. So there's a process that goes through that.
Excellent. Thank you so much. Dr. Parker?
How do you stay informed about changes in the criminal justice system?
So when I was in the role of deputy city attorney part of what I would do is I would review the case law updates from the Court of Appeals and the Supreme Court. They come out about weekly. It's not just criminal law, but it's, you know, every sort of law that could appear in front of the Court of Appeals or the Supreme Court. But my job in doing that was to flag criminal cases that could be important for police officers. I would compile a Word document that essentially summarized everything and then send it off to a contact person in Corvallis and then also Lieutenant Gursky here in Philomath. And so there were times where I would read a case and I immediately would email Lieutenant Gursky about it. So for instance, there was a case that went to the Court of Appeals where someone was stopped for driving over a road. And realistically, they were, you know, moving into a turn lane and just kind of quickly went over part of that end line. And the driver got pulled over for failing to maintain their lane. Then it was a DUI or something else like that. And it ended up being suppressed because the Court of Appeal said, well, this really wasn't a crime or a violation, this failure to maintain a lane, because they just drove over the lane really quickly and they were going into another lane. It was just, you know, an accident or, you know, they used a very particular word, but essentially it was so quick and so like it was not a huge departure, like they were on the line, they weren't over it by multiple tire lengths or anything like that. And so they said, you can't pull someone over and give them a ticket for doing that. And so a lot of times with police officers, when they do pull someone over for a traffic violation, it can lead to a bigger crime like a DUI or something else like that. And so it was important for our officers to know, as soon as I learned about that, hey, you need to make sure that if someone's failing to maintain their lane, they're actually failing to maintain the lane. Like it's not a quick touching the line or, you know, changing lanes and they just kind of go over part of the line, but they're, you know, in their lane. So making sure that they were aware of that as soon as they knew, because I definitely read reports where that's the reason someone gets stopped. So making sure that, or, you know, that they can articulate it in their report that, you know, how many tire lengths over the line were they or things.
Excellent. Thank you so much. Councilor Cosby.
Yes, my question is, how do you approach working with defense attorneys on a case? But I'd like to modify that slightly because Daniel, you said you've worked on the defense side and now you're going to work on the prosecutorial side, which seems to me like kind of a different mindset. So how do you work with defense attorneys and how do you change sides?
Well, having now done it and now proposing to go back, it is a mind shift. And I think that's one of the things that I think is certainly a strength among us is I'm still finding myself in that defense mindset and to shift and it takes time to change, which is a good thing. But I think that just strengthens what we do because I can anticipate what the arguments are. And Catherine, as a prosecutor, it didn't take much time. Just a few months, I started to say, oh, yep, she's anticipating what my argument is on this. She's anticipating what I'm going to say next. But again, it's approaching that from, okay, what is the goal of the defense attorney? I think the experience I had on that I didn't have when I was a prosecutor is we often approach it, you know, when you're in the prosecution role and as somebody who wasn't ever in trouble and went to law school and, you know, you were going to uphold the law and do all those other things and follow the rules. I didn't really understand what it was like to be a defendant. And so to me, you imagine in that scenario and you go, well, the only outcome I'd be satisfied with as a defendant is dismissal. The charges go away and I'm not in trouble. And that's the only thing that I'd be happy with. And certainly we have defendants who are that way. But what I learned as a defense attorney that I think is helpful then to change hats and be as a prosecutor is sometimes they're just trying to avoid one thing. Hey, I really don't want to go to jail. Or I'll go to jail, but I really don't want to pay a big fine. Or I will go to jail and pay a fine, but I really don't want to be on probation for 5 years. Or it's really important to me that I can leave the state of Oregon in 6 months. And so when you can identify what is it that is going to help maybe that defendant onto their path, I really want to be, I know we see it all the time in front of Judge Blake, I really want to be able to get my license back. I owe a ton of fines to the city. Okay, well, what steps have you taken in order to start paying some of those fines so that you can do that? What do we need to do with that? So that change of mindset helped, and then that helped me when I was a defense attorney working with Catherine to be able to approach her and say, okay, I know you're upset that my client was damaging this property. If we show, hey, they had an underlying drug problem and they've now gone into treatment, this is helping ensure that it doesn't happen again. It's helping that individual, and we're getting some of that accountability for that. Can we avoid them going to jail since they went to inpatient treatment for 30 days and they're kind of a similar, really go to inpatient than jail, but again, you're into a not controlled environment. So switching that mindset really helped me that when I was a prosecutor, I didn't necessarily think that way. Going to the defense side, you're at a disadvantage. You go, wow, I lose a lot, but what are the ways that I can kind of shift this around? And it helped me having had the prosecutorial experience because I knew, okay, there are some goals here, right? Because you get some defense attorneys who think, oh, the prosecutor, all they want to do is throw people in jail. All they want to do is get convictions. All they want to do is make people pay fines. And being able to say as a defense attorney to my counsel, well, listen, Ms. Pratt is not in here. She's not out to get you. But do you understand that if you're up at 3 a.m. yelling into your neighbor's house, that's concerning to them and that causes alarm and that's potentially dangerous behavior. That was helpful because then you get people around to, this is not just about an attack on you. This is really about resolving things and moving forward. And then hopefully you have people that are leaving, and there are defendants who leave the court feeling like they were heard and feeling like they were helped. And that's, again, not something that I would have thought of when I was initially in the prosecutor role, but now coming back to it, I'm like, okay, there's a way we can get people onto this track.
And I think that Judge Blake in particular is super conducive to being able to have those kind of, I mean, not specialized, but more targeted in terms of allowing someone to have certain things that would not generally be done at the big courthouse over in Corvallis. So, okay, you've been to inpatient treatment. Can you bring us a doctor's note and show us that? Those kind of things. And he's, definitely more willing to entertain those kind of proposals to try and get these kind of solutions. And that's, can be seen also because he does community court in Corvallis. And so what we've done is we've had people who are chronically houseless that have these kind of issues where they're only in court because they don't have housing or other underlying issues, and we have them go to community court in Corvallis. Because more likely than not, it was a situation where they were only here temporarily, got in trouble, went back to Corvallis, and now they're even just having issues coming here for court. Sending them to community court in Corvallis, because Judge Blake runs that as well, has been a nice additional resource as well, because the defense attorneys don't have to get involved when they go to community court. I don't appear at community court, and they can just talk to providers, and Judge Blake is there to make sure, that this is still a courtroom, you need to behave, but also we're trying to help you out.
Excellent, thank you. Councilor Nelson, would you like to ask that last question?
Well, not really, but because I'm always cooperative and never hostile. Have you handled cases where the defendant is uncooperative or hostile?
Judge Blake is very good at managing his courtroom, and I generally do not have to do anything. And also, it's not my job. I am one party. I've told people before, I don't want you to talk right now, not because I don't want to hear you, but because you do not have an attorney present and I don't want you to jeopardize your case. So kind of framing it as in one of those kind of things, potentially that's helpful. A lot of times there are big emotions, and it's sometimes just, you need to go, just take a breath, go to the bathroom, we can talk again later. Or, if it's something that being resolved, Judge Blake will resolve it.
Thank you.
Excellent. So with that, we've gone through the questions. Do you have any questions for us?
I think the only question I'd have, because we have a lot of experience both working together and dealing with Judge Blake and obviously, we've got a lot of contact with the work with. But I haven't necessarily got, certainly not this council, perspective on how do you view the municipal court and its role here in Philomath?
I will say that I've had pretty much zero interaction with it. It's thank goodness I stayed out of court locally. But yeah, I think it's functioning. I haven't heard too much complaints or anything.
I also don't have a ton of experience with the way it currently operates, but just through some stuff we've been like talking about at work, I do think it's something that maybe the council should pay a little more attention to, just since we do technically oversee it. You know, we have committees for police and finance and administration and public works, and then there's this other department that we just never talk about or deal with, which I mean is because they should be somewhat independent, but I really liked a lot of what you were saying as far as, you know, sort of offering other options for like community service or, you know, inpatient treatment. And I think we've been talking a lot at work about, you know, other ways that courts can work with community groups or other resources to connect people. So I think it might be worth us looking at sort of, is there something more our municipal court can be doing with that? So I don't have a ton of perception of the way it currently runs, because I also have not interacted with it firsthand, but I would like to maybe see the council be a little more involved in policy making on that moving forward.
Speeding is terrible around here, and it has not been getting better. And I see the reports, and I know how many stops are made and how many tickets are written and that kind of thing, and it does not seem to be dissuading the general public from speeding through our downtown in particular. And just wondered if you could comment on that a little bit, what you think we could do as a city from your perspective to address that.
So I don't want to take for granted that everyone knows how prosecutors work for municipal courts, but generally speaking, the prosecutors themselves don't enter into the timeline of a case unless it's a misdemeanor. The exception for traffic tickets for speeding, which are violations, and the difference between a violation and a misdemeanor being, with a violation you only get a fine, you won't go to jail, and a misdemeanor being that there is potentially a jail punishment component. So that's like Class C, Class B, Class A misdemeanors, and then there's violations. And so that's the Class C violation with measure 110, and then DCBA for other levels of violations. And the classification determines the minimum and maximum penalty, and also for traffic violations, the presumptive fine. So for speeding tickets, if you're going 10 over, there's a presumptive fine, but there's also a minimum and a maximum, and the judge can deviate from that presumed fine if they so desire for other reasons. Prosecutors for municipal court will get involved with a violation if the defendant gets an attorney. So if the defendant wants to have a bench trial on their speeding ticket and they go and hire an attorney, then the city prosecutor can come and defend the city. So that's the one time that for like speeding tickets when the city attorney's office and the city prosecutor would get involved. So just with that kind of
Well, our role is only this, we're only gonna show up for. That'd be, one example of that would be, hey, if one of the directives or something that BPD puts out is saying, hey, we're gonna enforce speeding more, now we're gonna have more of these trials where you have an officer versus a driver. That might be worthwhile, where we take an afternoon and come over and sit down and say, here's the things that you should be going through that's gonna help you to present this at trial. If you said, hey, we want to direct that there is I don't like to use this language, but there's like a task force, right, that we want for all the police. That'd be something that we could sit down and say, hey, if you're looking to up traffic enforcement, just as Catherine mentioned in one of her earlier answers, we want to make sure you're pulling people over for the right things, and that you're not just pulling people over and then dismissing all of the tickets because they're bad, we would certainly be happy to be part of those discussions.
And I was, since Catherine, you moved on and we've started using some Zoom in our cases, and how would that impact your ability to participate, or would you be?
We would still come in person, but
We're allowing defendants now to use Zoom.
that would be
We just
helpful.
started doing that, yes. I think from your perspective and our court clerk's perspective.
That would prevent the lingering, because a lot of times cases will also linger because someone is in custody in a different county. And we cannot have them appear in court because they are in custody and they are too far away to physically transport here. So that means we'd have to have a Philomath officer go to the jail they are currently housed in and then bring them here for court and then bring them back. So having Zoom is really fantastic for that purpose, but then also, from a defense attorney and, thinking about defendants that don't necessarily live here, as long as they are, staying out of trouble and they have essentially shown that they are in good contact with their attorney or with the court in general. So for instance, if someone is down in Medford, it is helpful to make sure that they are appearing, because I would rather have them appear and we resolve their current case than to potentially have them, get charged with the crime of failure to appear because they can't get a ride if their license is suspended or whatever. So that would be, I can only see that as a benefit. I imagine I would still want to be here in person though, but
Yes.
And are we good, or continue asking additional questions, or?
I just had like a clarifying question.
But so did other people.
So,
Yeah. So I was just saying, I was gonna go to Counselor Causey just because you.
right, I was just saying it was an additional question. It was, yeah.
Just building on your comments regarding your role vis-a-vis the type of case. So this may be a naive question, but depending on the cases that are coming that day, would your presence possibly not be needed at all?
potentially that's never happened as far as I'm aware. At best I get to leave early, but they have their traffic docket start at 9. And then if the traffic docket is light, they will immediately go into the criminal arraignment docket. I show up at 9 as well, because on their citation for criminal charges, they tell them to show up at 9. And what that lets me do is they check in with the clerk. I know who's here, and then I can go and talk to them before they talk to Judge Blake. And so that's, we try, and the reason I want to do that is to try to potentially resolve cases early. So for instance, if someone is eligible for a DUI diversion, they might not even know that. And then I can say, look, we have this form for, this program, you can read it. I can answer some very basic questions. I can't give legal advice, but if this is something you're interested in, we can get this over and done today. And then they have that opportunity, as opposed to, go to Judge Blake, get a court-appointed attorney because they don't necessarily know what's available to them, and then potentially incur that cost, and then even potentially the city incur that cost if they can't pay that amount of the fee, and then the city would eat it. So, having that process, that's why I would show up. Then they have at I think 10, 30, and 11 cases that have attorneys on them. And so if there weren't any cases with attorneys, then I would just simply leave when I'm done with all that, because they generally try to put traffic trials. So they try to sandwich them out, arraignments, trials, and then attorney cases. But if it's light in the afternoon, which is usually the case, it's not usually light in the morning and then heavy in the afternoon, then I'm usually in and out, or I would get in at 9 and be gone before noon. Very rarely staying after noon.
And I know we have 5 minutes, and kind of know Councilor Conker has a hand up, and then also, no?
The video was my question.
More?
You were talking about the sort of work you used to do about sending the sort of, updates to the police department. I guess I was curious, would that fall under city attorney services, or would that be what, would you still provide that now that we're potentially splitting it up? Because I could see that going either way, where that is kind of like a legal advice, city attorney thing, but it is also specifically related to like traffic and enforcement and prosecution.
I guess that's something we could discuss. I imagine that for me, it's beneficial just to be in the know.
Sure.
But I also, I know that Chief Rubin has his conferences with other police chiefs, and so they also will discuss these things. The police certification program that the Philomath PD uses, they also will release kind of like general updates that they would advise, saying, you might want to adopt this internal policy or be aware of these kind of changes. Chief Rubin is very on top of things and generally knows these things. And, for instance, with the case about the going over the line, so failure to maintain the lane, he was aware of it. So,
Okay.
he's very good about keeping up on that. And, so is Lieutenant Gursky, because they essentially function the same way. So that could be something we talk about, but I think it would just depend on what council wants.
I think it's general information. It's similar to, like, you can sign up for some firms newsletters, like I'm signed up for other city attorneys. And they sort of send something out like that as just kind of a heads up. So I think it's.
Yeah, and again, I think just to clarify, we're not gonna point fingers and go, that's a, city attorney proper job, not this job. If we think it kind of touches municipal court and makes us more efficient, I think that's something that we're gonna be willing to say, yeah, we're gonna do.
Okay.
Thank you so much for being here. Yeah, if you have any closing thoughts, we do appreciate it.
Missed municipal court.
Hey, you left.
How many lines do we have that we can keep coming back? We'll talk a lot, especially, I think, Philomath to me will just not one place in my. Wanting to keep coming out here and having the opportunity to do that. We appreciate the opportunity to be here. We hope to have the opportunity to move forward with the municipal court. We really like being out here, love the community, and just kind of see ourselves in line with how things operate. Again, thank you for the opportunity and having us all.
Yeah, appreciate it.
Excellent.
Check. All right, well, big class. Yeah. Done.
If you can give your matrix scores tonight while it's top of mind, and if you want to give those to Chelsea before you leave. Any piece of paper that you wrote any notes on, please send me those together and get those before you leave. Going forward, we're going to have an executive session at the November meeting to talk about employment. And so we'll go through more depth, insights and preferences and all that kind of stuff. But what staff will bring you is the scoring totals and averages. And kind of have that prep for you for that discussion in November. Any questions on process or where we're at? Okay, thanks. That was a long night, but good reviews and great questions. I appreciate your efforts.
Thank you all. Good night. Adjourn.
All of the papers back right now.